CLS Talks.
Talk to me.
CLS Talks.
Talk to me.
CLS Talks.
Talk to me.
CLS
Talk to
Talks.
me.
Real information.
Talk to me.
Real education.
Talk to me. Talk to me. They don't talk to me. They look like that morning. They don't talk to me. They back that morning. They don't talk to me. They back that morning. They don't talk to me. They back that morning. They don't talk to me. They back.
Welcome back to the CLS Talks. It's always action-packed here, but it's more action-packed than ever because we're going to go live to the courtroom where poor old Tom, who's been arrested and manhandled and tortured and treated in a very inhumane manner, in my opinion, up to now, he's fighting for potentially his freedom in the courtroom. Luckily, Judge Catherine Staines was on hand to join myself and Des Carty, and she's actually going to read her own transcript of the court case. So Des, I'm very excited about this. You must be too.
Oh, that was very nice of her, really. It wasn't very convenient.
She's lovely.
And we have to thank Judge Catherine Staines for playing her part in it, or as she likes to be called, Cathy.
Yeah.
And I think I'll take up the role as Garda Mahoney, and you can take up the role as Tom.
Grand. Sounds good to me.
Have the three-way dynamic, and then afterwards we'll do a bit of an analysis of it and explain a lot of the stuff to the listeners.
Sounds great. Over to the courtroom we go.
I swear by Almighty God to tell the truth, the whole truth, and nothing but the truth. So help me God.
Your Honour, Garda Mahoney has a notebook there, and it wasn't preferred to me as evidence under your Gary Doyle Order.
Did you give him a copy of your notes?
He didn't ask for them.
Did you ask for the notes?
Yes, we asked under the Gary Doyle Order twice, and they ignored it. They haven't offered it as evidence.
Just a moment now. With regard to the Gary Doyle Order, what a Gary Doyle Order is a system of setting out the evidence in your case. Now, unless you specifically ask for it to be regarded, they would not normally be sent. Do you want to look at the notebook? I'll allow you to review it in this case.
Your Honour, having read the law on a Gary Doyle Order, it states all the evidence that they have. Now, if he's using that notebook, we need to examine a copy of it.
Under the Gary Doyle Order, a Garda is allowed, with permission of the court, to refresh his memory by looking at his notebook. That in itself is not evidence. But if used as evidence against the accused, for example, if a mistake was made or something of that nature, a Gary Doyle Order sets out the summary of the evidence against you.
Your Honour, we have a recording of the events, and we're very confident that Garda Mahoney has notes in that notebook that contradict these recorded events, and that is why he's withholding this evidence.
You can have 5 minutes to review the notebook.
Your Honour, my point being, if you let me speak, is that the Garda should have given it to me as their evidence. They had 5 months to give me all their records. They didn't give me any of the...
The Garda notebook is not evidence. Now, if you specifically want to see the Garda notebook, because it may be used to refresh his memory, it's not part of the Gary Doyle Order. Now, if you're specifically requesting it, that will be no problem. I'm giving you an opportunity to review it. The Garda may or may not decide to use the notebook to refresh his memory. If he does use his notebook to refresh his memory, we can't have you shouting out, "Can I see his notebook?" before you refresh your memory. Just to be sure, there is nothing pertinent in the notebook of that nature, so I have allowed you the opportunity, so I will not adjourn the case. Just to be sure, there is nothing pertinent in the notebook of that nature.
We just wanted on the record that they're willfully withholding evidence.
No, the notes in a Garda notebook do not constitute evidence. Now, if you could leave it now, I want to proceed with this case. Thank you.
We advised them that if they were happy with what they had, that was fine. But now they've brought in new evidence.
Don't take the moral high ground with me. Notes in a Garda notebook do not constitute evidence. Evidence is what the Garda gives orally and what he's given you a copy of a statement. Isn't that right? What is the evidence you required?
Your Honour, we're not happy with that.
You're not happy with the ruling and you feel I'm acting with outside my jurisdiction? Please feel free to go to the High Court. I feel I have answered that point. Now, if we could move on.
Your Honour, we want to put it across in a way you can understand it.
Mr. Murphy, If you continue to obstruct the court, I will have no choice but to consider you in contempt of court. Now, I've ruled against you on that point. If you want, I will give you an hour to look at the notebook. How many sentences are in the notebook? It's 2 or 3 lines. Is that right? I've made my ruling.
There are notes before and after that, Your Honour, in the notebook that we want to see because we've a recording of the events and want to compare all of his notes with all of the other Garda's notes.
His notes consist of 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 lines. And I have had sufficient time to look at these notes and I'm moving on. Thank you.
So you're allowing that in, Your Honour, with all that we've objected?
Of course I'm allowing it in.
Your Honour, just for the record, we have given over an attested copy of the licence and insurance to the court.
Now, have you shown either the licence or the insurance to the Garda?
No, as we wish to cross-examine the guards.
No, forgive me now. This is a charge of not having a driving licence and insurance. I don't want to spend 3 hours or 2 hours listening to a case if you have a licence and insurance. That's probably the end of the matter. I'll dismiss your case if your licence and insurance are valid.
Your Honour, we need to get across to you what the guards have done, the duplicity and aggression they've shown.
They seen the driving licence and insurance?
For the record, in front of you in court in Tullamore was denied access in my defence to those documents by the Garda. For the record, this was stated to you in Tullamore and you ignored it. We do not want the Garda to see them as we may be using them later in the High Court.
If you're submitting something to this court to take into account in your case, the prosecution are entitled to see it.
Your Honour, they're withholding evidence. Why are we not allowed to see their evidence? They are withholding evidence. Your Honour, for the record, we were categorically denied access to any of this stated information. We said this to you in Tullamore for the record.
I granted the Gary Doyle Order in your name, and I seen your letter written on the 12th of March acknowledging receipt of statements from the Garda. Now, one final time, notes from the Garda notebook do not constitute evidence, and the court has allowed you to see copies of the Garda notebook, and you did not state that you wanted to see the notes from the Garda notebook.
Your Honour, we will quote you the Gary Doyle Order now if you like.
Mr. Murphy, this is a prosecution. Now the state is attempting to give their evidence. Now, do you think that matters are in order?
In relation to the insurance aspect, Judge, he's not the policy holder.
Why don't you read the documents properly, Garda?
Would you please stop interrupting, Mr. Murphy?
I just have to check. If he's the policy holder, he is entitled to drive another vehicle. But if he's a named driver of the policy, I'm not sure he's afforded that opportunity, given that he is not the policy holder.
Your Honour, the Garda is giving evidence to something he has no first-hand knowledge of.
I'm just having a chance to look at what you've entered for the court.
Your Honour, why did you let him see that? Why did you let him see it?
You put this before the court, then promptly take time for us to see it. That's part of your defence.
We want to see all of the Garda's notebook to compare the facts.
Garda, thank you. You don't need to share as evidence. Just proceed with your case.
On Wednesday, the 24th of October 2012, there was a checkpoint in Portlaoise in place, and I was performing a vehicle checkpoint. I observed the motor vehicle, a grey Saab, approach the checkpoint from the Abbeyleix direction. My colleague Garda Clark, who was at the side of the road, also, and another colleague Garda there. As the vehicle approached the checkpoint, I noticed there was one male driver. I had a look at the windscreen and observed the tax disc and insurance disc that was displayed. I thought to myself that the insurance disc and the tax disc appeared to be false. It didn't appear to have the consistency of a true tax disc and insurance disc. So I signalled the driver to stop by raising my right arm, and the vehicle moved alongside me, and I spoke to the driver. And I indicated to the driver to pull in to the left. The driver never lowered the window, and he drove slowly and drove by me. At this stage, Judge, I would have knocked on the rear driver's window of the vehicle and instructed the driver to pull in, and he failed to do this and continued on the road. At that stage, Judge,
Who was the driver? You didn't know at this stage?
No, it was the defendant. I went back after the vehicle. I went back to my patrol car and I followed the vehicle as it made its way towards Portlaoise. The blue lights already activated on the car, and I activated the sirens a number of times to alert the driver that I wish him to pull into the side of the road. Eventually, Judge, the driver stopped. Now, where he stopped was in the middle the best way to describe it is a two-way carriageway. The other carriageway is on the left, a yellow line on a yellow line marking. He was stopped in the middle of the yellow line marking and in the middle of the carriageway heading for Portlaoise. I alighted from my car and I went back to speak to the driver. Now at this stage the driver, he opened the window 2 or 3 inches, and when I asked him to pull into the side of the road, he became very agitated and repeatedly asked why. At this stage, I believe, Judge, he was on the mobile phone and was talking into the mobile phone, and I believed he could have been making an attempt to record the conversation as well. I again asked him, could he pull in the vehicle into the side of the road? He again continued to question me as to why. I explained to him that the position he was in was dangerous and there was a number of cars behind me and they would have to go out on the wrong side of the road to overtake my patrol car and the vehicle. I asked him would he move the vehicle into the side of the road so I could speak to him, and he refused to do so, Judge. I then instructed him and directed him to move his vehicle into the side of the road, and again he said he would not. I then demanded the production of his driving licence. Again he refused to do so. I demanded immediate production, then Judge, and then he refused to give his name at all stages, shouting at me why and refusing to do so, and asking me what powers I had. I explained, or tried eventually to explain to him as best I could, that I believed he had committed a road traffic offence and I was entitled to demand his driver's licence and his name, and I explained on numerous occasions that I wanted him to pull into the side of the road. At that stage he just continually kept asking why and would not interact with me. I opened the door of the car, pulled the car door back, I opened the door of the car and pulled the door back, and then he took off driving towards Portlaoise. Just before that, I had to summon assistance because of the volatile nature of this gentleman who was displaying. I summoned assistance. He took off driving it towards Portlaoise, and I followed in my patrol car, and my colleague Garda Kenneth Larkin then came to assist me. Judge, he was travelling around 60 kilometres per hour. I would have had the siren on for about 3/4 of a mile out the road before the vehicle stopped eventually on the side of the road. At that stage he simply got out of the vehicle and placed his hands on the back of the roof of the passenger side of the vehicle, and I arrested him under section 17 of the Road Traffic Act. The time of arrest was 10:20 a.m. I conveyed him to Portlaoise Garda station, where I then subsequently charged him with failing to present documents under section 17 of the Road Traffic Act. He refused to give his name following the charge. He refused to identify himself. To this day he has still refused to verify his name and address to me, Judge. I subsequently brought him before you at Tullamore Court, District Court, and on a number of occasions I've demanded the production of his driver's licence in accordance with the Redemption Act. He won't hand them into the Garda station. He would go from a position where he would engage me in a conversation, but then I would try to make a formal demand or serve him any formal documentation on him. He'd blank me and he would not talk. The discs on the vehicle, Judge, subsequently turned out, the insurance turned out to be a fraudulent disc, Judge.
Can I see them?
Your Honour, we have not been proffered any of this as evidence. Your Honour, the Gary Doyle Order, they have not provided any of this information to me as part of the Gary Doyle Order, and they're relying on it as evidence. Your Honour, we object to this.
If we could take this into account?
Your Honour, we object. We have not been given any of this evidence. They have not provided us with a copy of the discs under the Gary Doyle Order and have not given them to me as evidence.
Has he seen a copy of that?
No, not that I'm aware of.
Your Honour, that's repressing evidence. How can we go on if we haven't got it? You gave the order to give me the evidence and they didn't.
Are you going to listen to me, or are you going to shout over me? You're making an allegation that the Gary Doyle Order has not been complied with and that evidence has been withheld. Now, in order for me to verify whether that is true or not, I need to see what you have been furnished with.
Your Honour, we'll show you exactly what we were furnished with. These are the exact documents that they gave me. They have withheld evidence.
Now let me read it. That was sent out about the evidence against you.
Judge, you're wrong there. That is an evidence about an alleged conversation he had with Allianz, which is unsubstantiated. None of the evidence on this has been properly documented. There's nothing documented, Your Honour. We haven't documents on anything, Your Honour.
I'll break now for lunch and give you a chance to look.
We object to that, Your Honour. The Garda had 5 months. 5 months to send me this evidence, and they did not. They withheld it and are now trying to bring it in without giving us a chance to examine it.
Again, would you please stop shouting over me? Now, I've read out from the bill for the Gary Doyle Order, which sets out what evidence is against you in relation to this issue. The actual disc mentioned earlier, we cannot give you because they are evidence. Now, if you like, I will give you 1 hour to look at this. You'll have to look at it in the presence of a Garda, as it is the original evidence.
Your Honour, with respect, you gave them 5 months to give that evidence over, and they did not.
The Gary Doyle Order, there is compliance. Now, the Sheriff can help you with my decision. You can take the matter further.
We will be taking it further, for the record.
Very good, that's your constitutional entitlement.
Do you want to look at this? We're affording you the opportunity, Mr. Murphy, to look at this if you want to.
They don't talk to me, they look like blue that morning.
CLS talks.